Welcome to Antitrust Matters, a Constantine Cannon podcast where we have engaging and timely conversations about competition policy in the digital age. My name is Jeff Shinder, and I'll be your host. Antitrust has always mattered to consumers and businesses, but today it is also in the public discourse more than ever. From how we get our food on our plates, to how we travel, to the way we interact daily using digital apps and platforms, antitrust touches each and every one of us in ways we may not even realize. In Antitrust Matters, we bring you perspectives of experts and visionaries in the field who discuss where antitrust law has been, where it is going, and why it matters today more than ever before. Hello, everyone. We are back for another episode of Antitrust Matters, and we have an interesting topic and an interesting guest today, our first journalist. Welcome, Amanda. We have Amanda Hamilton, a senior correspondent at Capital Forum, and I'm also joined by one of our rising stars from our DC office, Wyatt Fore. Welcome, Wyatt. Amanda and Wyatt are here to discuss private equity and the antitrust issues that the increasing prevalence of private equity investments across many sectors of our economy, the issues that that is having, and whether the antitrust laws as currently configured are well suited to addressing those competitive issues. Let me just introduce Amanda. Amanda is a senior correspondent covering antitrust. She joined the Capital Forum after working as an attorney in the Office of the General Counsel for the U.S. Consumer Product Safety Commission. Prior to that, she was an attorney at the United States Postal Service, an antitrust associate at Haugen Partners, hopefully I did not mispronounce it, and a staff attorney in the Federal Trade Commission's Bureau of Competition. Amanda holds a JD and a BA in economics from the University of Iowa, and we are really pleased to have her on the pod. Amanda, welcome. Welcome, Wyatt. We have two newcomers today, and we have an interesting topic that is cutting edge in antitrust. And I wanted my colleague from DC to kind of tee it up and explain it a little more. And Wyatt, so I'm going to turn to you to start. And why don't you tell our audience a little bit about why private equity is an interesting topic in this moment of antitrust ferment, and that raises unique issues that the antitrust laws in some form or fashion should address. So we'll turn the baton to you.
Wonderful. Thanks, Jeff, and welcome, Amanda. So one of the sort of animating sort of questions I had for this podcast was in the last 30 years or so that the American economy is seeing the rise of these sort of giant non-bank financial institutions, including private equity and hedge funds and shadow banks and that sort of thing. And there's a flurry of investment activity throughout the sort of real economy, so to speak, and that this trend sort of mirrors, in my mind, and to a lot of commentators, the trend that we saw in the late 1800s, early 1900s that gave rise to the original Antitrust Act, where you had, because of these sort of baseline financial interests, that there's increased coordination among sort of traditionally separate horizontal rivals, that these investments might have sort of competitive effects that are not sort of immediately ascertainable. And because of the rise of what I'll call, I guess, private equity, but sort of non-bank financial institutions, that's happening in real time, and that there's a lot of sort of questions and concerns about that rise. And it's one of the things that our existing legal and economic tools are a step behind and are trying to catch up with, trying to figure out what are the effects of these investments, what are the effects of these giant financial institutions that are sort of underlying a lot of the American economy. And so that's one of the things that I'm interested in. There's been a focus by the Biden enforcers on these private equity institutions, but as Amanda well knows from her reporting, that they're sort of a step behind what's happening. And so there's a question of, okay, well, what's the appropriate legal tool to sort of address this? How do we think about these problems? Are they problems at all? How do we measure the competitive effects? Are there competitive effects? And so there's a sort of lag between what's happening in the financial and real economy, as well, a lag between that and our legal and economic tools to evaluate them. So that's the sort of overarching capital P problem that I'm thinking about when I was trying to think about a guest for this podcast. And I thought that considering Amanda has extensive journalism and reporting on this, that she would be a wonderful guest to introduce to our audience on them.
Okay, so Amanda, let me turn this over to you. So from your perspective at the Capital Forum, what are you looking into? What are you interested in? What are you seeing that relates to the issue that Wyatt just articulated?
Yeah, no, absolutely. So a lot of our subscribers, at the very beginning, Biden's enforcers, Jonathan Cantor over at the Department of Justice, Lena Kott over at the FTC, issued a lot of statements surrounding private equity. Majority of their statements were related to whether or not private equities were good stewards of assets as a divestiture buyer in mergers, or even just how to evaluate whether or not a certain merger or their acquisition violates Section 7 in a very traditional sense. So whether or not this merger should go through, whether or not they should buy this asset. But the FTC and DOJ has moved past that. And where our subscribers are particularly interested in, they want to know what are the antitrust, what should they be expecting? How are antitrust enforcers foreshadowing how they plan to combat their the issue that they had spotted, which is private equity. One of the ways Jonathan Cantor has been very vocal about how he wants to revitalize Section 8 enforcement, which is looking at interlock directorates. And he's made good on that promise. Recently, as October, he announced that 7 individuals resigned from 5 different company boards. And he said that that's just the beginning of the end. And there's also been reports by Bloomberg that DOJ has subpoenas out and CIDs out to massive private equity firms looking at the Section 8 problem, one being Apollo. And he's also mentioned that how private equity roll-ups, so a private equity firm acquiring competitors within a horizontal space, could potentially be attempted monopolization. And he's not alone. FTC has joined him in his enforcement calls. So FTC recently issued a revised policy statement saying that, look, it's very clear Section 5 goes beyond the Sherman and Clayton Act. There are things we can reach, and we're looking at things that affect competitive conditions, and there's a lower burden of proof for this. And that's okay because we're an expert agency. So it's interesting to see how Lena applies that in a private equity context. And then on the sidelines, you have the academic community, which Cantor and Chairwoman Khan are very close to as well. And they're asking the FTC and the DOJ to shift their focus to horizontal shareholding. In that context, you have non-controlling minority, where, for example, investors will have a non-controlling minority interest in a highly concentrated industry, but buy stocks in every single member of that industry or each market player. And so the academic community has shown that the results are clear, that has resulted, and they believe, in higher prices. And so they've been looking at that as well, my understanding. But I guess my question to you guys as private enforcers is that we have this revised policy statement from the FTC that's looking to go pretty far. My question to you guys would be, what would be a great test case there? And would horizontal shareholding kind of be a good test case for the FTC to take on there?
So let me take the first crack at answering that, but I actually want to take this conversation from the abstract to the more tangible or particular by quoting from a Harvard Law Review piece that Einar Elheg published on horizontal shareholding. And his piece opens with the following, and this is fascinating. He opens with this, quote, "An economic blockbuster has recently been exposed. A small group of institutions has acquired large shareholdings in horizontal competitors throughout our economy, causing them to compete less vigorously with each other. For example, from 2013 to 2015, 7 shareholders who controlled 60% of United Airlines also controlled big chunks of United's major rivals, including 27.5% of Delta, 27.3% of JetBlue, and 23.3% of Southwest Airlines. More generally, institutional investors held 77% of the stock of all airlines operating in the average flight route from 2001 to 2013. A new econometric study shows that this sort of horizontal shareholding has made average airline ticket prices 3 to 10% higher than they otherwise would have been." That's the opening paragraph of Einer's piece. I haven't actually had the benefit of crawling into the econometrics that he cites there. So I'm not here on this podcast to bless those numbers, having put forward a lot of economic experts in our cases and understanding the complexities of econometrics. But I would say the following to answer your question. The policy statement on the revised deployment of Section 5 calls out interlocking holdings and directorates as a potential test case. And the background of Section 5 deals with incipient harms to competition. And I would think that in particular industries, and I'm not sure whether airlines is the best example, financial services is another that Einer calls out. I know the private equity, and Mike can speak to this, is deeply involved in healthcare. I mean, their tentacles are far and wide in the economy. So the selection of the industry in question is one that has to be done with some care. You would want to have some ability, likely through econometrics, to understand the price effects. And maybe have a situation where there's a pre-existing set of structural investments across an industry where you can isolate that price effects are happening. And then private equity is deepening their investments in ways that would intensify a pre-existing problem. That could be a good use of Section 5, because what I take from Elhag's piece is that you don't need majority interests across these companies to see competitive issues, that what he's identifying is a tendency to pull competitive punches in the absence of Section 1 conspiratorial activity. And those outcomes are harmful to consumer welfare, and they would not be condemned by the Sherman Act. But they strike me as exactly what Lina Khan is trying to accomplish through a re-energized deployment of Section 5. Picking the right case is critically important. As an economist on a recent pod said, the facts matter. In fact, he suggested maybe we rename this the Antitrust Matters. The facts matter. The facts matter. And the facts would matter that this has to be really thoughtfully selected. But private equity interlocking holding type case strikes me as a good use of a re-energized Section 5. Wyatt, I don't know if you want to comment on that, or you want to speak to Section 8 and Jonathan Cantor's activity there. I'll toss it over to you.
Well, I totally agree with everything that you said, especially about the incipiency point. I mean, part of the problem in my mind about the Sherman Act is that Section 1 and Section 2, okay, so under Section 2, you have to have a firm with monopoly power, which is a very, very high standard. I mean, in sort of casual parlance, people think of monopoly as being a market of one, although, economics and law, there's more fuzziness around that. But then if you don't have a monopoly, then you're stuck with Section 1, where you have to have an explicit agreement. And so there's a gap in oligopolies where if you have a market with, for example, 3 firms, those firms can coordinate and pull punches and not compete vigorously in a way that would fall below an explicit, for example, price fixing agreement. And the trend over the last 30 years in this country is going from competitive markets to oligopolistic competition. And those oligopolistic markets are largely insulated from sort of scrutiny under the Sherman Act. And so we have to look at other tools outside of Section 1 and Section 2 to address those. And the prime one that government enforcers use and private enforcers can use as well as Section 7 is that, okay, well, in order to prevent, a market where you have a lot of competitors to a market where you have few competitors is Section 7, preventing these transactions. And so I think that Jeff's point about incipiency is really important, is because there's all these markets, and airlines allegedly being one of them, where you used to have a lot of competitors and now you have relatively few of them. But absent a sort of explicit price fixing agreement, it's really difficult to address competition concerns there. And so looking at Jonathan Cantor and Chairman Khan's sort of more expansive view of government enforcement, I think is incredibly important and appropriate and to address these situations. So, I mean, Jeff, you mentioned interlocking directorates. That's certainly one mechanism by which private equity can sort of exercise restraining competition in oligopolistic markets. But also I think that Section 7, in terms of common ownership, horizontal shareholding, but also Jonathan Cantor was quoted as saying, okay, well, actually, this might also be a theory of attempted monopolization. So I think that in terms of our legal tools, we have legal tools for it. It's just that we need to update those tools to the fact patterns of the 21st century. And I think that, as Professor Olhag Einer, however, he's sort of surveyed the economic tools the economic research on this is pretty clear that oligopolistic markets have restrained competition in a way that's directly harmed consumers. And so we just need courts and enforcers and private enforcers and governments to update our tools for the 21st century.
So Amanda, let me go back to your FTC experience. And we have a policy statement that just came out that seems to signal a sea change in how the FTC is intending to deploy Section 5. And I'm interested in your view on how that compares or contrasts with the deployment of Section 5 back in the day when you were at the FTC.
Yeah. So when I was at the FTC, it was Chairwoman Ramirez, and Josh Wright was also one of the commissioners as well. And I think that one of his kind of like lasting legacies was to strip Section 5 and essentially just having it to reach outside of Sherman Act and Clayton Act to reach an invitation to collude. And I have to say that I know there's been a fair amount of criticism of FTC staff over the years. I have to say that even the most conservative members of FTC staff, people who have clerked on the Fifth Circuit and whatnot, were incredibly upset by the narrowing of Section 5 just to invitations to collude. I think that was a disagreement among political spectrum of how far Section 5 should go. But I think that there was essentially a consensus, at least among the younger members of staff, that Section 5 was the tool, and it was a tool that we could use to combat competition problems, and we should certainly take it for a ride. And how far of a ride was a disagreement. But I think that there was certainly a consensus that perhaps leaning towards Chairwoman Khan's vision of Section 5 enforcement.
So would it be fair to say, in your view, that the policy statement that just came out is a pretty significant sea change in the direction of the FTC?
It's an incredibly significant sea change. I mean, while I understand that it's like a broad policy statement to set parameters, the focus is turned from whether or not a conduct impacts competition to competitive conditions, which just certainly opens the door. And I think was very nicely added by Chairwoman Khan as well. And also, it seems to me that while certainly a smart enforcement articulation of a standard, it seems to me that there is a lacking of perhaps a burden of proof. And I think that the way that they managed and was stewards of the FTC maybe imposed higher burdens than maybe was necessary for them to do so in the past. So
let me turn to you, Wyatt. We've got Section 5 of the FTC Act and a re-energized commitment to Section 5. That seems to be the direction of the commission. We have Section 8, the generally long dormant but long-standing prohibition against interlocking directorates. They have Section 1, attempted monopolization under Section 2. So they're different tools. You make a point that is interesting, that the exercise is to apply those tools in a 21st century setting in a way to make them more effective, given the challenges that we face today, which has been the history of the Sherman Act. And antitrust law generally. So amongst those options, which do you see as the most potentially important in terms of dealing with the problem of private equity?
That's a great question. I think that my general view is all of the above, that we have a lot of tools, that a screwdriver doesn't necessarily do the same thing that a hammer does. And so I hesitate to put too much emphasis on one. I do think that the Section 8 investigations and communications with private equity firms has been really important. In many respects, it's the lowest hanging fruit. It's a per se violation. If you establish that certain conditions are met, it is automatically a violation of the law. I think that because it's long dormant, that a lot of companies are violating the law, and it's very important for them to sort of be aware that this is a risk. But also, I think that because interlocking directorates, it's intuitive to see why that's a competition problem, that even though it's a low-hanging fruit, it's an important one because it sort of re-educates the wider community on how horizontal rivals can coordinate in a way that's problematic. to get to your sort of the meat of your question, what's the most important tool? I would say it's not the lowest hanging fruit, but in my mind, Section 7 is severely under-enforced, especially among private enforcers. I would love to see the private bar become more active on this. I would also like to see government enforcers. It's difficult to say for them to be more active on this because this really is the bread and butter of the DOJ and FTC is their Section 7 merger enforcement. But I would really love to see a test case to sort of articulate how these theories of rival coordination through private equity firms. I think that certainly the public inquiry with respect to revising the horizontal merger guidelines asks the public about economic and legal tools that the enforcement agencies can use to address issues of private equity in horizontal cross holdings or common ownership situations. I think that it will be really interesting to see how the agencies respond to that. And then once they sort of have those economic tools as incorporated in new guidelines, if it exists, will be really interesting. So I would really love to see a test case under Section 7 exploring these issues because the sort of traditional advice that you always hear that horizontal merger bad, vertical merger good, that sort of rule of thumb doesn't really apply to the 21st century with as much strength. To answer your question, I think that Section 7 is very important and wide-reaching, and the legal tools that we have are more easily updatable to the fact patterns of the 21st century. But I do think that I would like to commend the government enforcers for using Section 8 interlocking directorates, because I think that it's a low-hanging fruit that educates the wider community about the possible competitive effects of these arrangements.
I have a question for Wyatt. A lot of the pushback I get from our Capital Farms readership is that, look, if it's a novel legal theory and the government's not likely to win, they shouldn't be bringing it at all. And I guess like with a lot of these test cases, because it's treading new ground, I mean, should the government not be bringing these cases unless they're sure to win? And I would love to hear your thoughts on that as a private enforcer who probably would love to bring a lot more cases, but probably have financial reasons for not doing so or resource reasons.
Well, I'm going to let you have that first, but I definitely want to weigh in on this one. So you go first.
Yeah, and I think that that's a great question. I mean, my general view is that the government is in a strong position that it's something that we all know that courts struggle with antitrust. And when the United States Department of Justice or Federal Trade Commission comes in and makes a point that courts listen to them in a way that they don't listen to private enforcers as well. I will say that my view is that this is not as novel of a legal theory as I think the sort of the judiciary or the wider business community thinks. I mean, if you look back to sort of earlier Sherman and Clayton Act cases, that this sort of idea that horizontal rivals can affect each other's competitive decisions through a common ownership or a common trade association or whatever is actually well trod in the antitrust sort of legal precedents in that. That's why I tend to use language that we should update it for the fact patterns of the 21st century, because in my mind, this isn't really new. It's just kind of forgotten. And so it's really important to draw the judiciary's attention to the fact that there are these precedents that exist and that we can apply them. I also think that a lot of whether or not these cases live or die really depends on the economic evidence, and that we already have really good economic evidence about this problem. It's just applying it to a particular case. I will say that obviously the government has a very strong institutional position that it doesn't like to lose. And so unfortunately, that means that they have to bring good cases and win them. And that's easy for me to say as an armchair sort of coach on the sideline. Cheering them all on, I realize that these are very resource intensive and difficult, and there's a lot of sort of procedural and logistical reasons why they might not bring a case, but I would like to just encourage them to find a good case and bring it and to win. And that's kind of all there is to say. And it's easy for me to say it on the sideline, but that would be my suggestion, is that you can't sort of update these laws without cases, without sort of carefully educating the judiciary on them. And that can only happen in the context of a good case that's well run and well litigated and well argued.
Let me add to what Wyatt said and perhaps be a little more iconoclastic about this, which is I think it is the wrong standard for the enforcers, FTC or DOJ, to select only cases that they are very confident in winning. Antitrust cases are hard. The good ones are always hard. It's, as I say to many clients, there are no slam dunks in antitrust. And, there are a lot of good cases where there is some prospect of defeat, particularly because the court may misapprehend the economics, or a judge, particular court's political leanings are against vigorous antitrust enforcement. for whatever reason. Risk of loss should be accepted as a reality of the enforcement of the antitrust laws, and it should not chill the bringing of cases. And I wish I could remember who said this recently, because I would quote, I think it was a hymn on this, but someone I remember recently said, the government has to bring cases and maybe lose them or lose some of them to reorient our culture around antitrust enforcement and generate more education at the judicial level. And that may be part of the process, that sometimes you got to bring cases and lose them to advance the ball, which may seem counterintuitive. The other thing that I want to speak to, because this is something that frustrates me, is I understand we have a lot of corporate clients. I've counseled a lot of corporate clients, and in-house counsel wants predictability in how things are going to be enforced. But the reality of the antitrust laws, which, by the way, informs some of the current judicial hostility of the antitrust laws, is that most cases are adjudicated under a rule of reason standard. Per se rules have largely fallen away, not completely. There's some left. But the greater the zone of the rule of reason, the more unpredictability is introduced into antitrust outcomes because they're fact dependent. As I said earlier, quoting the economist on our last podcast, the facts matter. And you hear the corporate community say, well, we don't know. This is novel. We don't know what the rules are. And I say to that bunk at the end of the day, sophisticated antitrust counseling, which every company that operates in highly concentrated industries, they have antitrust lawyers who are embedded, who understand their business. They understand the give and take and the complexities as to the facts. And they get counseled and they take their risks accordingly. And what I would caution the audience and you and your readers is sometimes what's commentaries around, well, we need bright line rules. And the Sherman Act is too vague. What's a restraint of trade, or what's a monopoly or an attempted monopoly? And, this is really just a backdoor way of attacking antitrust enforcement, and it's ideology more than serious discussion of the law. That's my perspective on your question. Amanda, I'm curious to know if you have a reaction, and if pushback, I'm happy to have pushback.
Yeah, I guess one of the things is that I wonder if the media is responsible for that. Because, Jonathan Cantor over there is bringing very heroic government challenges, and he suffered 3 losses in a row, and some of them are up for appeal. And people have more in the media has been focusing on the losses and not necessarily the burden. And kind of the federal judiciary is the one who adjudicates these cases. So where we're focusing on the fact that DOJ lost, the media is doing that versus what tools he has at his disposal, how difficult it is to prove those cases, and the federal judiciary's role in that. Would it be more helpful to maybe government enforcement efforts if the media focused more on the judiciary's role on that and the dual tools that are at his disposal? Like, for example, the rule of reason, that's a really difficult burden for a government enforcer to prove.
Well, I'll give you my reaction, but Wyatt, I can't criticize the media for some focus on the obvious outcome where they have brought a series of cases and lost. They've also won in some instances. And so I'd like to focus on that as well. These are hard cases, and courts sometimes get things wrong. I know there's some effort within the federal court system to help judges get educated on the economic issues that antitrust cases bring to bear. And that's a good thing. My hope would be that the government enforcers are not responding to media pressures. I'm sure if they were on, they would say they're not. I think the current regime has really done a good job, and I credit both the FTC and the DOJ for really trying hard to find new ways, innovative ways. I like Wyatt's approach of updating the law, but the facts change. Our economy changes. The competitive challenges change. And the antitrust laws are there to meet them. And they're really doing their best. And I laud what they're doing. And hopefully the media, will in their own way. Although I can't blame them for reporting on negative outcomes because they've happened. And that's not necessarily a bad thing for the ultimate enforcement of the antitrust laws, which is going back to my previous point. Wyatt, I don't know if you have any further thoughts on that.
I totally agree with what you're saying. That's where I think that presumptions are the enforcer's friends, especially in the merger guidelines. Speaking off the cuff, there's no law, to my knowledge, saying that you have to have merger guidelines. The agencies just do that to provide some comfort to the business community about how they're going to enforce the antitrust laws. And I think that the merger guidelines have been really important to educating the judiciary about the economic effects of transactions. And the enforcement agencies are looking at the economic evidence and they're sort of drawing a dotted line in the sand saying, okay, well, because of our updated knowledge about economics and HHI, and we have all this economic research about how HHI concentrations above a certain level can lead to bad unilateral effects and bad coordinated effects. And so therefore, we're going to sort of say, as a rule of thumb, that mergers that increase HHI concentration above a certain amount, there's a presumption that we're going to challenge them in court and that we've met our prima facie burden. And I think that this has been a wonderful tool, not only for the business community who has certainty, but also for antitrust practitioners who are interested in sort of updating the laws pursuant to emerging economic research. And I would like to see a lot more presumptions broadly in antitrust law about these. I mean, there's emerging economic evidence about how certain tools like MHHI, a modified index, can capture the likely competitive effects of horizontal cross-holding. You know, certainly our firm does interesting transportation work, and in the sort of oceanic carrier context, there's emerging economic tools in addition to MHHI that sort of capture the likely competitive effects of certain arrangements like joint ventures and consortia. And I think that what the enforcement agencies are doing, asking the public, asking economists, okay, what tools do you think are helpful? And then responding to those comments and incorporating them into transaction guidelines moving forward. I think that that's a very appropriate way to act, and I would like to see more presumptions.
So, Amanda, I'm intrigued by the question you asked us, and I think I heard you correctly, and if I didn't, you'll correct me, that your readership is critical of the notion of government enforcers bringing, and I put it in quotes, novel theories. That's something that is that they're hostile to on some level. Yeah, can you expand on that a little bit? Exactly what is their perspective? Where is it coming from, your sense?
Yeah, I mean, I think their perspective is, and I'm certainly parroting them, but they see it as bad governance. It's just raising former Commissioner Phillips said it best when they're just increasing the M&A tax. So go in for a deal that normally wouldn't be challenged. It gets challenged. You spend all this money in federal court, and just for a judge to rule, okay, this deal's fine. There's no Section 7 violation here. And so the way that they say that if they could predict it from the forefront, that just raises the tax of the deal. And that's certainly not the way that business has been done in the past. But I guess in some ways, the good governance, they have a good point. They shouldn't be raising taxes, M&A taxes on certain things. But I do think that the context of private equity, my days as an FTC enforcer, when we were, and bouncing off divestiture offers off of customers, and this is a long time ago, was a lot of the customers would say, anyone but private equity would be an appropriate divestiture buyer. But it's not until today where Chairwoman Khan is now saying, no, no to private equity. Like, we're finally listening to you consumers. But I guess going back to what my subscribers are saying, I think they were saying, like, look, here's another example of good governance. Not all private equities are slash and burns. Not all private equities are created equal. They're not all the same. And so they see this as kind of a wholesale kind of condemning private equity, where private equity has some benefits. They believe in investments, stimulating startups and generating new competition. And so I think this is another example where some of our subscribers would say this is another example of bad governance.
So I appreciate that answer on a couple of levels. One, going back to the facts matter theme that's come up a few times, I'm certainly not expounding the position that private equity is bad, and necessarily generates anti-competitive outcomes. It depends. It always depends. So I appreciate that comment. Your overarching answer triggered the following thought in me, which is almost a philosophical discussion around antitrust, which is, what's worse, the false positives or the false negatives? And I just think wherever you sit on the ideological divide in terms of antitrust, your answer to that will be really predicated on ideology more than economics, more than law. So your constituency, at least the portion in which you're talking about, the false positing and positive in terms of enforcement, the costs of that are a tax. And that's a problem. That's what they're saying. And Wyatt started the discussion with, look at the last 20, 30 years, 40 years. We can take it back to 1980 and the beginning of the serious Chicago School era, really. So it's 40 years now, 45 years of the Chicago School. If you take it all the way back to Sylvania and all the false negatives, and what have they contributed to? Highly concentrated, oligopolistic economy, higher prices for American consumers. And so what's worse? And that's the question. So I will put that to you. False positive, false negative. Both of you, if you want to speak to it. And Amanda, you could channel your audience if you like. What do you think? What's worse? I'm challenging both of you.
I guess just putting on my personal hat, I mean, I certainly think false negative is much worse. I think, and putting on my former enforcer hat, I think I remember being at the FTC and growing increasingly frustrated by us not bringing more actions and perhaps just not being more bullish on transactions or even conduct. And perhaps in certain instances, maybe articulating a prima facie case that was probably higher than maybe what a court would accept. And I think that we just increased the burden for ourselves. But I think channeling many members of my audience, they would certainly say a false positive is much worse because you just increase transaction costs and, you reduce predictability and then there's lower transparency. So they would argue, and as a former defense attorney, I would also argue there's a lot of companies out there, if they were aware of the risks beforehand, they probably wouldn't enter into the transaction in the first place. But once they're there, they're just going to kind of go for it. But I leave it to Wyatt.
Wyatt, you can't dodge this one, so have at it.
I think that Amanda's comments are really insightful. There has to be, the challenge is sifting through the transactions, for example, and practices that are pro-competitive or competitively neutral from the relatively small category of transactions and conduct that are very problematic. And so I think that over the last 40 to 50 years, maybe shorter than that the dial has been way too geared in one direction, that the concern against false positives has far outweighed the false negatives. And I would like to see it sort of moderated a bit. I think that it's difficult for businesses and the business community who are trying to who have a non-problematic transaction. I think that Commissioner Phillips' comments are well received, that for a lot of conduct and transactions where there's really no issue, that raising the tax for those transactions is problematic for the economy. And certainly I worry about overregulation and over-enforcement with respect to those. But because most of my work focuses on the problematic conduct, I am continually frustrated that to see what defendants get away with that are with their problematic activity, that they essentially pay no price or pay pennies on the dollar compared to the anti-competitive effects. So unfortunately, Jeff, I'm also going to evade your question a bit because I'm not so sure if there is empirically a question about whether or not false negatives or false positives are worse. But I think that sort of the burden shifting framework of the rule of reason helps to sort of sift through these problems. And that I think that I would appreciate a perspective that goes more towards the middle of weighing the difficulties for both of them, as opposed to now where I think that people are or that enforcers and judges are so worried about false positives that they're letting so much problematic conduct go wreak havoc on our economy.
And one thing I'll add to the give and take, and I appreciate your answers, is the role of the private bar. We've been talking about the FTC and the DOJ. Obviously, there's no private right of action under Section 5, so the private bar does not have those tools, but it definitely has Section 7 tools. It has Section 1 and 2. And the private bar is important in all of this. And one concern I have is the death by 1,000 cuts to private enforcement that has been ushered in over the last X number of decades. It's much, much harder to certify classes and get class action certified, and the class device is important. The law around arbitration clauses is an issue. And private enforcement, we need all this, if it's a three-legged stool, we need all three legs to support the stool, and private enforcement's important. So with that noted, I want to give each of you a last, if there's any final thoughts on this topic before we wrap up. Amanda, I don't know if you have any questions or thoughts that this conversation has generated.
Yeah, I mean, I think that there's always new issues emerging. And just because government hasn't necessarily taken action on those issues in the past, it doesn't necessarily mean, I think, that previous government enforcers necessarily rubber stamped those issues. Like, for example, like how loss of competition led to job cuts, or, for example, agreeing on wages that no one before necessarily saw that as an antitrust violation. And, recent government enforcement action had that. So as a reporter, Chairwoman Khan and AAG, Cantor has certainly made my life more interesting. And it's certainly made it more difficult to crack cases and to report on what's happening, because it's not always so clear, because they are looking to reinterpret antitrust laws and bring exciting new cases. But I will say that it certainly made my life interesting.
Wyatt, I'm happy to give you the last word if you want it.
Always stressful. No, I would only reiterate that I think that some of the smartest people in the country today are attorneys and economists working in the enforcement agencies. And I think that they do, in general, a wonderful job with a very, very difficult task. And so any criticisms or suggestions that people make, I hope that they know that they have a lot of fans on their sides, that they're doing the best with the very limited resources they can with a large set of problematic tasks, and prioritizing them and tackling them are always challenging. And so I would just like to give a shout out to our quiet government enforcers who certainly do the Lord's work every day under very challenging circumstances.
Well, Wyatt, I'll say that resource constraints is something that's important to point out. They are under-resourced, and they really are doing great work under somewhat difficult circumstances, and it's appreciated. Amanda, I want to thank you for coming on the pod and bringing the Capitol Forum and the perspective of your readership to this conversation. It was great. Wyatt, I appreciate your insights in organizing this pod, and we will definitely have you back. And I think we can conclude. That's all for our show today. If you like the podcast, make sure to subscribe to Antitrust Matters and leave us comments on how we were doing or on the topics you would like us to cover going forward. You can also follow us on Twitter at CC Antitrust, or follow the Constantine Cannon Antitrust team on LinkedIn. Until next time, be well, and remember, antitrust matters.